again, everyone. I'm attorney Robert Flessas. The videos that I'm making on debt buyer lawsuits are generating a lot of questions from my viewers. If you're new to my channel, I've discussed how companies called debt buyers are purchasing debt from creditors for as little as pennies on the dollar. Then they use a shotgun approach across the United States, employing collection attorneys to sue people on the debt. Many people being sued don't show up or answer the complaint. They get an immediate judgment against them and the case is over. The practice of debt buying is entirely legal. However, if you're confronted with a lawsuit like this, you need to be prepared to fight. As the defendant to the lawsuit, you need to challenge the lawsuit by employing various defenses to the debt buyer's case. First, you'll be served with a summons and complaint. These are the legal documents that the debt buyer filed with the court to sue you. Next, you'll either need to answer the complaint in writing by filing your answer with the court and/or appear in court on the court date. Before you answer, you need to read the complaint and the attached exhibits carefully to craft your answer. Do the exhibits include a copy of the account or written contract between you and the original debt creditor? If there's no proof of the debt attached to the complaint, you may be able to get the court to dismiss the lawsuit on the first court date. At the first hearing date, you can request that the court require the debt buyer to provide information on the debt. The documentation must include proof that the debt buyer has the right to sue you to collect the debt. Well, what kind of proof is that? The debt buyer needs to show that the debt was assigned to them by the original creditor. Without that, they're going to have a problem. Do they have in their possession a document that shows that the original creditor assigned their interest to the buyer? That's the document you're looking for. Do they have a receipt showing that they purchased the debt directly from the creditor? If the debt buyer can't show that they own the debt, then the legal theory of standing to sue comes into play. You didn't enter into an agreement with the debt buyer, right? Proof is required to be submitted to the court by the debt buyer showing that they purchased the debt and they have standing to sue you in court to collect. The words set forth in the debt buyer's complaint against you won't cut it. They need proof. If the debt buyer can't show that they own the debt, then you can ask the court, of course, to dismiss your case, or you file a motion with the court for that reason. Now remember that every state has different laws, and the courts in different jurisdictions have different evidentiary rules when it comes to the evidence that's required for a debt buyer to prove their case. I have a lot more videos on this topic. There's even one that will walk you through a typical debt buyer written complaint. I'd like to know your experience with a debt buyer lawsuit. Tell me the city and state where you're from. I can't give you legal advice, but if you follow my videos, you'll have a good idea to educate yourself when you attempt to defend yourself. I'm attorney Robert Flessas, and thanks for watching.